XRP is entering a new level of development. How much money do you think this will bring to investors? Write answers in the comments. The current triumph is surely a last nail in the coffin. The issue is whether the SEC will abandon the complaint or negotiate a settlement with Ripple. The court's decision to deny the SEC's appeal confirms an earlier judgment that secondary XRP sales do not fit within the category of securities transactions. This demonstrates that Ripple's activities in selling XRP tokens do not violate securities legislation. Judge Analisa Torres's judgment dealt a blow to the SEC's legal approach and exposed several significant flaws in its claims. The SEC's approach was predicated on the argument that some XRP sales might cause investors to expect rewards based on Ripple's initiatives. However, the court deemed this argument to be devoid of significant evidence, confirming the prior ruling. Ripple's CEO, Brad Garlinghouse, didn't pass up the chance to remark on this recent event in his X post after Deaton. He humorously observed that the SEC, in its pursuit of applying the Howey test in the case, ended up on the losing side. He mocks the SEC's own creation of this test, on which they were slammed in court. They seem to want the services of an expert lawyer to comprehend the significance of their own made-up securities legislation. Looking forward, the SEC now finds itself in a situation where it must await additional findings in the overall litigation against Ripple before considering any appeals. The next central hearing is scheduled for April 23, 2024, with both parties needing to file pre-trial materials by December 4, 2023. According to Jeremy Hogan, the matter will either go to trial in April or be dropped. Furthermore, this judgment enhances the judge's prior ruling, making it more difficult for the SEC to win in any prospective appeal. As the current tide is moving towards Ripple and Coinbase, the SEC may be in a stronger position if they act in their best interest to introduce clear crypto legislation. The SEC is at a crossroads. In a recent disclosure, digital asset researcher Anders revealed why the U.S. Securities and Exchange Commission, SEC, chose to go after Ripple and XRP. The SEC's allegations against Ripple in December 2020, citing the sale of XRP as an unregistered securities offering, sparked discussion in the crypto world, especially among XRP fans. In his thread, Deaton offered a range of thought, provoking questions about the SEC's special targeting of XRP. He questioned why the SEC would choose a more difficult case, drawing parallels to the early sales of ETH when the Ethereum team launched a simple initial coin offering ETH. Anders points out that the SEC's determination to target XRP arises from Ripple's creative usage of the digital currency in cross-border settlement. According to Anders, Ripple's use of XRP undermines the conventional nostro vostro accounts and banking paradigm, which has long been a substantial income source for many big banks. According to the researcher, this disruption has the potential to expose established financial institutions' lack of innovation. It is critical to note that Ripple Labs is mainly focused on transforming blockchain payments, with XRP playing a critical role. Ripple removes middlemen in cross-border settlements, which reduces delays and expensive transaction fees. Notably, ODL uses XRP as a bridge currency to provide smooth conversion between multiple fiat currencies. Following a federal court judgment, Ripple continues to stress XRP's non-security categorization, cementing its status as a valued asset in the cryptocurrency ecosystem. Notably, Riplex disclosed that the XL's 39 clawbacks feature, which is scheduled to be live on the XRP, is now up for vote. With the news accompanied by skepticism from community members, Ripple Stu 2 David Schwartz stood forward to give his perspective. Schwartz has attempted to assuage concerns about this new function. He initially highlighted that the clawback functionality would allow token issuers to reclaim a particular number of issued tokens from existing holders. He explained that he was originally opposed to the functionality since the XRP already had the freeze feature, which is identical to clawback. However, he said that the obvious contrast between clawback and the freeze function convinced him to reconsider. In his instance, Schwartz said that the clawback capability would find a main use case in court conflicts. He feels that the opportunity to reclaim some cash in the event of a disagreement relieves the token issuer of the legal responsibility. According to Schwartz, this precaution is crucial for complying with court mandates. He feels that without the clawback capability, auditing protocols on the XRP would be impossible. To further define the capability as a tool that enables for surgical strikes to maintain the XRP intact as opposed to freeze, which is a more nuclear option. Overall, Schwartz said that this new functionality is now available in blockchains with stablecoin inhabitants. He said that if the plan fails to pass, token issuers would have to go through the effort of activating the functionality one way or another. Other major figures in the XRP ecosystem, like Raythof Ghaneman, have also worked to debunk falsehoods concerning the clawback function. According to him, there is no hidden modification in the XRP ledger ecosystem. With the issues addressed, the clawback functionality will be implemented after 80 of existing validators vote yes on the proposal. For the proposal to fly, the minimum threshold must be maintained for at least 2 weeks. The XRP has undergone a considerable revamp in recent months, with a number of new features suggested. As previously reported by the Crypto Basic, the developers behind the XM wallet advocated an update of the XRP infrastructure to encourage participation via incentives. Spend the Bits, a payment mechanism on the XRP, won first place in the Ripple CBDC Innovate Award, a showcase of the ledger's exemplary work. While the cryptocurrency world awaits the official outcome of the judicial fight between the United States Securities and Exchange Commission and Ripple, the blockchain company's community has opted to celebrate an earlier triumph this weekend. Specifically, the Proper Party, which took place on September 30, drew not only XRP and Ripple enthusiasts, but also people closely involved with the ecosystem and the lawsuit, such as Ripple CEO Brad Garlinghouse, David Schwartz, legal experts Jeremy Hogan and John E. Deaton, and many others. Garlinghouse tweeted a few photos with the crowd gathered outside the venue just before the party, adding that the event was a celebration of collaborative success and a reminder to the SEC that court decisions matter and that progress is worth fighting for. In a video shared in an X post by CryptoLaw on September 30, Garlinghouse said during his speech at the celebration that it was "this village beat the bully," referring to the XRP and Ripple community and its stand against the regulator. Previously, CryptoLaw shared an article written by Frank Francone, a Centennial Institute policy fellow and a California attorney, who stated that the SEC's central argument failed almost completely under judicial scrutiny, harming a lot of innocent people in the process, not just the defendants in the case. As CryptoLaw founder John E. Deaton noted in an X post published on September 28, in response to Francone's claims in the essay headlined "The SEC is not the king," 75 IG investors, users, developers, and small businesses have been screaming the above for 3 years, he said. Meanwhile, lawyer Bill Morgan emphasized the SEC's arbitrary enforcement, adding that Mark Berger was pro-crypto when it came to Ethereum Lubin, but while deputy director of the Division of Enforcement sued Ripple. More recently, on October 1, Jeremy Hogan emphasized that the SEC attempted a similar maneuver with gold in the early 1980s, when inflation was high and gold was the investment, and that the court stopped it at the time.